Good evening. It's now 6 o'clock. I'm handing over to Dr. Mark Human. Thank you. Dr. Human, over to you.
Good evening, folks. I think we've lost a little bit of light. Give me 2 seconds. That's better. My apologies. Since we did our screen test, the light outside dropped. Welcome everyone, and thank you for joining us to our webinar this evening. It is the first in 4 webinars that we'll be hosting during the month of September. Essentially, this is aimed at the medico-legal, how best to frame this disaster state in which we find ourselves in this country at the moment. Our current contingent liability, so that means lawsuits that are outstanding, that should they all get paid out for healthcare in this country, is close to half our government annual health budget. Just think about that for a few seconds. That should terrify everyone. Of course, many of these are long shots and lawyers gambling on 100-to-1 value for their claims, so it's highly unlikely that anything like 130 billion will get paid out. But that's where the current contingent liability stands. And so this is something that all of us in the medical profession really need to pay some attention to. Tonight's webinar is essentially about what governs us, the regulations and the statutes that govern the practice of medicine and the legal aspects around that. And I'm really privileged to be introducing my colleague and fellow board member, Dr. Munyadziwa Kwinda, to you all. I'm always humbled. It's funny when you read someone's bio, you may have known them for some time and think you know them quite well, but when you read their bio, you suddenly realize that they have an incredible wealth of experience and qualifications. I always feel humbled when doing that. So let's tell you a little bit about Dr. Munyadziwa Kwinda. He's a medical specialist, basically practicing mainly in family medicine. He has a master's in bioethics and health and has a bachelor's degree in law. So he's got a very keen interest in the medico-legal environment. He was the ombudsman at the Health Professionals Council of South Africa for 9 years, from 2014 to 2023. And he's currently the CEO of Chalma Trust and serves also on the board of directors of SAMA. He's got more than 20 years of experience in clinical care and in managing various organizations at both senior executive and non-executive levels. Most notably are some of the publications that Dr. Kwinda has made. 2 really interesting ones that caught my eye were in the Journal of Bioethics and Law. He wrote an article about disciplinary hearings against healthcare practitioners facing criminal charges, the role of the Health Professionals Council. So tonight's not really about criminalization. We're having a separate webinar about that, but it's very topical at the moment, most notably with people like Dr. Peter Beale standing trial for murder. Another article was in the Journal of Contemporary Roman and Dutch Law, and this should really interest all of us. Inconsistent and irregular approaches in the handling of complaints by the Health Professionals Council of South Africa. Well, I think we are all aware of that. Some of us have seen it firsthand. Some of us have even been on the receiving end of it. Clearly, there needs to be some degree of consistency. There has been the suggestion that perhaps to register a formal complaint at the Health Professionals Council, one should have to sign a police affidavit or something similar. This is giving the complainant some actual vested interest in making them make some effort, as opposed to just anyone who can write a complaint letter. And these are maybe good ideas and things that we can discuss. But without me waffling on any further, I'd like to hand you over to Dr. Kwinda. Dr. Kwinda, the floor is all yours.
Thank you, Mark, for that introduction, and good evening, colleagues, and appreciate the leadership of Sama for seeing it fit for me to contribute to this September month of medical legal webinars. And I'm not going to really waste time, colleagues, but just get straight to the presentation. Just please confirm if you can see the presentation.
We can see it. Thank you, Dr. Quinda.
Thank you so much. I will be dealing, colleagues, with the regulation of health professions in South Africa. And also the second aspect to this presentation is on the Health Professions Council, especially specifically professional conduct processes. That is what I'll be dealing with generally. Now, let me say this up front that I'm not a slide person. I prefer to speak from my heart, and please, if I don't move slides, I will just run through them, and this will also assist in managing the time that we have, which is quite very little time that we have at our disposal. It's very much important, colleagues, for us to understand our regulation as health professionals. We need to understand that we don't exist somewhere in space. We exist in a country, in a state that is governed by laws. We are in South Africa, and hence we are regulated by the statutes of the Republic of South Africa. That's why you have got entities like the Health Professions Council of South Africa. And for those who are in other professions, you do have the other statutes like the Nursing Act and the Pharmacy Act and so on and so on. Now it becomes important to understand how South Africa is governed and how the government is structured. And the first thing to understand that we have a three-tier system. It's a constitutional democracy with a three-tier system, which is basically a national level and provincial level and also the local level. And I think, colleagues, we know this already. But fourthly, very much important to mention then that we have the independent judiciary. Now, from that level, then we understand that from the three-tier system, you have got both the legislative function and the executive function. And I will dwell more for the purpose of this evening to the national level that is applicable to what I'm going to be talking about this evening. That at a national level, then we have the legislative authority, which is Parliament with 400 members of Parliament. And this year it makes more sense to us because we have just voted in May. So as to who should sit in that Parliament, we had an opportunity to hire and fire. And I was just reflecting on this to realize that as South Africans, that is the opportunity that we have. And indeed, we have fired some people and we have hired some. That is at a national level. Now, that is called the legislative authority because it is responsible for making laws, amending laws, and also repealing them. So when you talk about the Health Professions Act, is one of the act which is an act of Parliament that establishes as an institution like the Health Professions Council of South Africa. So the Health Professions Council of South Africa is a creature of statutes. It did not create itself, meaning that because it is a creature of statutes, it can only operate within the four corners of the Health Professions Act. They can't do anything outside that act. If they do anything outside that act, then that becomes ultra vires, or they are acting outside the law. That is at a national level. Then that is now a Parliament, legislative authority. Then another level is what we call the executive authority. The executive authority, that is where you have the president, the vice president, and also the ministers. Now, the executive authority is responsible for executing. That's why there's a word executive authority. They are responsible for policy. That's why in the acts of parliament, any act of parliament will refer to a minister who is responsible for that particular act. In terms of our act, which is the Health Professions Act, that will be the Minister of Health. Now, the act itself will empower the Minister of Health in executing the Health Professions Act to make regulations in terms of that particular act. That is the role of the executive authority. Then number 3, we have the judiciary. The judiciary is responsible for the dealing with the disputes. I always say that although there is issues of respect of powers, within the government itself, but it seems like the judiciary to a certain extent becomes more powerful because they can set aside a statute or a provision in an act that has been agreed upon by 400 people in parliament, but at the level of the judiciary, where the maximum number of people at the constitutional court who can declare that act or that provision of the act unconstitutional, maximum is 11, and they can overturn the decision of almost 400 people who sit in parliament. So that is the issue with how our government is governed. Now, I want us from there then to pick up how then are we regulated. And I just want, before I get to that, to talk to the issue of law. When we talk about the sources of law, we have the Constitution, which is the supreme law of the land. Then we have got statutes that I've referred to earlier on, made by the legislative authority, which is parliament. Then following that is what we call common law. Now common law is coming from the Roman Dutch law, which was imported into our legal system when South Africa was still a Dutch colony. Then we have what we call case law. Very important. I always say from the health profession's point of view, what we call, the rulings, ethical rulings, is the equivalent of case law. But this now is a reliable source of reference to all important reported cases during the period 1947 up until today, the judgments that have been made by the courts today. Then we have got customary law, which is basically the law that is only applicable to certain individuals or certain people who decide to be governed by such laws. Just check something here with my slides. I've got this bar that is disturbing. Okay, thank you. Now, I'm going now straight to how, as health professionals, we are regulated. And we have got the Health Professions Council of South Africa established in terms of the Health Professions Act. We have the nursing council, and I'm not going to deal with a pharmacy council with the Pharmacy Act, Allied Health Professions Council of South Africa with the Allied Health Professions Act. Then we have got the Dental Technicians Council of South Africa. They have got their own status. Then we have got the Interim Traditional Health Practitioners Council of South Africa. Those are basically the councils that we have. Now, when we zoom now into how the councils regulate healthcare providers under their ambit, it starts with the primary legislation. That is the act. That is the one made by Parliament. Following that, as I said earlier, you move to what we call secondary or delegated legislation, meaning that in an act of Parliament, what Parliament will do, they will delegate the making of laws, which are secondary or delegated legislation, to other people, starting with the minister or even the entities like the Health Professions Council of South Africa. So basically what you will find in most of the acts, this secondary legislation will include regulations made in terms of that particular act, proclamations, government notices, public notices, rules, and policies. Now, in the context of the Health Professions Act now, and I'm not going to dwell much on this because I think just mentioning it is more than enough. That's why you will see in the Act, there are references in particular sections that will talk to the minister making regulations on a particular matter, and also prescribing by regulation on a particular matter. But of interest is that you will also find in the same Act where council is also empowered to make rules. When it comes to the level of rules, rules are made by the council, whereas regulations are made by the minister. For example, rules relating to continuing professional development, and so on and so on. Now, also the rules in terms of section 49(1), the so-called ethical rules of conduct, those are made by the council in consultation with the professional boards. So as you can see, issues of publishing of the fees in terms of section 53, issues of notice in the Gazette in terms of exemptions. And so that is basically how then regulations is done in terms of all this council. You're gonna see the same pattern with the Nursing Act, the Pharmacy Act, and all the other statutes that regulate the health professionals in South Africa. Now, just want to touch a bit, colleagues, on the issue of professional self-regulation. And I have to mention that I think this is one area that we need to revisit, especially in the context of the Health Professions Council, in terms of, are we really self-regulating? But just to emphasize that, in fact, because of the social contract that exists between society and the health professions, then self-regulation become a privilege that has been given to us as professionals to regulate ourselves, meaning we have to set and maintain standards for our profession, for education and training, registration, which is entry into practice of that particular profession, and then practice of the profession itself, and also how we maintain our competence through continuing professional development, but also very importantly, to hold each other accountable in terms of those who breach the standards that have been set through discipline or for unethical, immoral, or incompetent practices from members of the profession. So that is what self-regulation is all about. And this has to be done by the professionals themselves. And that's why, colleagues, when you look at the definition of self-regulation itself, it says it's a regulatory model in which a profession governs or manages itself with minimal or no assistance or influence from outside the profession. That's why, colleagues, when we have to say who regulates us, who is registering us, it has to be somebody who is in the profession. And I think that is one area that we as health professionals registered under the Health Professions Act need to really look at, to say who is really driving our self-regulation. Is it driven by us as health professionals, or there's so much influence that is coming outside the profession? Now, the state of government grants self-regulation status to recognized professions through legislation. That's why we speak about now the Health Professions Act is the act that also in it grants that self-regulation status. And as I said earlier, it deals with matters of governance, education and training, registration, practice of the professions and continuing competence, and also the issues dealing with complaints. Now, I'll also deal with the issue of the challenges, colleagues, that we have. Sorry about that. I think I moved. The point I need to make also, which is something that personally I've been looking at, to say, is self-regulation through acts of parliament effective than self-regulation that is not regulated by law? And I just think of institutions like SAICA, the South African Institute of Chartered Accountants, there is no act of parliament that establishes SAICA. The same applies to institutions like the IODSA, the Chartered Governance Institute of South Africa. Those are institutes that are even recognized even by entities and organizations to a point where in certain instances, you may not be able to occupy certain positions if you are not a chartered accountant. And the only organization that has got a professional designation of a chartered accountant is SAICA. And although these institutions are not regulated by an act of parliament, they've got professional designation by SAQA. By the way, even us who are regulated by an act of parliament, there is still a requirement in terms of SAQA for these professional designations to be recognized by SAQA. But these organizations have got this professional designation where somebody is called a chartered accountant because it's a professional designation that is recognized by SAQA. And they do have their own exams. They do have their own standards of that particular certification. That is self-regulation, not under an act of parliament like us who are regulated by an act of parliament, but self-regulation that is non-statutory. And I need to mention this, that one of the challenges that have been picked up over the years, and this is one of the things, colleagues, and I need to mention this, that there has been failure in terms of self-regulation where society now, while it's part of our discussion this month, the issue of the criminalization of medical errors and so on. And it's getting to that. The question we need to ask ourselves as a profession is, how are we doing in holding each other accountable? When one of us have breached our ethical code of conduct, or some of us are incompetent to practice the professions for which we are registered, how well are we doing in terms of that? Is not society losing trust in our ability to self-regulate, where instead of us dealing with ourselves, then some of us have to be dragged into the criminal courts and so on? And it calls for also the time of reflection in terms of how we are dealing with the issue of self-regulation. Now, let me just touch quickly, colleagues, on the issue of the difference between the councils and the professional association, because many a times there is this confusion. Maybe the first thing I need to mention is that none of us is a member of the HPCSA. Usually we make these mistakes. You can be a member of an association like the South African Medical Association, but you cannot be a member of the HPCSA because membership is voluntary. That's why some of you are here. You volunteered not to be members of SAMA, but I hope tonight you will take the opportunity to become members of SAMA because it's voluntary. But when it comes to registration with the HPCSA, for you to practice your profession, you need to be registered. So that's why that one is a requirement for you to practice the profession in the Republic. You must be registered. And council is delegated by government through the act that established that council, and it focuses on matters of education and training. As I said earlier, I'm not going to repeat this for the sake of time, but that is what the regulator is responsible for. On the other side, the association deals with advocating for and promoting the profession, lobbying government on issues that support the best interests of the public, and providing continuing education opportunities for members. Today, you're going to leave here with ethics points. This is one of the things that an association will do for you. Providing practice information and resource for members. For example, if you are in the private sector, you need those codes to be able to claim. Hence, you have the South African Medical Association having the doctor's coding manual and so on. That is what associations do. And there are many other benefits that association will have for their members. But the fact of the matter is that the interest of the association is not primarily the public, it's primarily its members, because if your interest is the public, then you can even lose members. That's why some of us complain and say, why is the HPCSA protecting the public and not protecting us as professionals? The HPCSA's role is to protect the public because it's established by the public itself through an act of parliament, but it guides the profession. But the interest of the profession is more with the professional association. That's why we need to support the work of the association, because it's the association that looks after the interests of the profession, whereas the regulator looks after the interests of the public while guiding the professions. Let me move now to HPCSA professional conduct processes. Now, the first thing, colleagues, you need to understand is that the powers to discipline practitioners does not lie with council, by the way, it lies with the professional boards. And in terms of Section 49 of the Health Professions Act, council then make rules that will be used, specifying the acts of and omissions in respect of which a professional board may take disciplinary steps. But it's very much important to note that the board is not limited to those acts or omissions that are prescribed in the ethical rules of conduct or the rules made in terms of Section 49, meaning that the board can go outside those particular rules at an inquiry level where they also consider the guidelines. Now, let me just explain something quickly here so that you understand how things are structured. The guidelines are basically guiding you in terms of the rules, but they also go further to guide us in terms of the practice of our profession. And one of the most important guidelines that you need to be well acquainted with as a practitioner is booklet number 1, which is really general guidelines for the practice of the profession. Is quite very important, but you do have some of the guidelines that are not based on any rule, but majority of the guidelines are guiding us in terms of the ethical rules of conduct. So in considering a matter at an inquiry level, the board will even go into the policies of the board itself if there has been a contravention of such policies. Now let's look at the regulations that have been made that regulates the handling of complaints, regulations relating to the conduct of inquiries into alleged unprofessional conduct under the Health Professions Act. Now, the aspect of lodging of complaints in terms of regulation number 2, all complaints are addressed to the registrar. What the registrar does, and this function is delegated within the structures of council, is to peruse, analyze, and categorize those complaints according to their significance and seriousness. And those complaints that are of minor transgressions are referred by the registrar to the chief mediator for mediation. By the way, for your information, chief mediator is what used to be called an ombudsman. That has been changed in the regulations that were promulgated on the 1st of June 2023. And then matters not falling under the jurisdiction of the council, then the registrar has to refer such matters to the relevant authorities. Now, complaints of serious transgressions are referred to the preliminary committee of inquiry. Now, that is the first level of the board that deals with complaints. Now, very important, who can lodge a complaint? And I just need to explain a few things here because we do have some case law in terms of who can lodge a complaint. In terms of the regulation, a complainant can be any natural person or juristic person or a group or a professional body, even including a professional association or society like the South African Medical Association, a teaching or training institution, or any healthcare or related facility. Everyone can, even you as a practitioner. By the way, in terms of ethical rule number 25, you can be charged as a practitioner if you do not report somebody who is involved in unprofessional conduct or somebody who is impaired. First thing, those who are impaired are required to report themselves. But if you are aware of somebody who is impaired or involved in any form of unprofessional conduct, you are supposed to report that person, and your failure to report that person, you can also be charged for that. So very importantly is that one does not have to be a practitioner patient to lodge a complaint, and this was decided recently in the case of Mapolisa. Mapolisa is one of the pro forma complainant or legal advisors of the HPCSA who fought this case of against the Professional Conduct Committee, where it was said that the person who lodged a complaint was not the patient, and then he won this case at the High Court. The second one is the one dealing with also where an association, for example, participate in a petition that relates to the complaint. This was decided in the case of Basson versus Yuho. And here is when you are a SAMA member or a member of an association that is involved as a complainant. If your association is involved as a complainant, you cannot participate in any disciplinary processes of that case at the HPCSA, meaning that if you are a member of the preliminary committee of inquiry and you know the complainant is your association, you need to recuse yourself from that process. If you are a member of the professional conduct committee, you need to recuse yourself. Don't even allow yourself to be appointed into that committee as long as your association is a complainant or your association participated in a petition that relates to that particular complaint. Very important to note that, colleagues, because you don't want to be embarrassed when you are singled out of all the members of the Professional Conduct Committee to say you are conflicted because you are a complainant, because your association is the complainant on this matter. Now, in terms of the determination of jurisdiction, this is the matter, colleagues, that has been before the court, especially in the case of the HPCSA versus Hrif. This was one of the interesting cases in that, in fact, Hrif won this case at the High Court, where Hrif, in fact, had patients of his that he recruited into his investment company, and then the company did not make it, and his patients who were investors in his company lost their money, and they reported him to the HPCSA, and Hrif raised a point in limine to say the HPCSA has no jurisdiction on this matter because he was not performing his professional act. This is related to the issue of finances, and he took the matter for review in the High Court, and the High Court agreed with him, and the HPCSA appealed that decision. That time, I was still part of the HPCSA, and I was involved in us having to appeal the decision of the High Court at that particular time. And then the HPCSA won the case at the Supreme Court of Appeal. But of importance is that this judgment establishes jurisdiction of the HPCSA. And the recent judgment relating to this relate to the case of Ramatuba, who was saying, I was doing that as an MEC of health. And the court said, though you are an MC, there are two bases of jurisdiction, basically. One is that, are you registered with the HPCSA? Two is the allegations, if proved, if they constitute improper, disgraceful, or dishonorable, or unworthy conduct. And these, colleagues, is quite very broad. It can go to anything, especially when you look at the definition of unprofessional conduct in terms of Section 2 of the Health Professions Act. And one other aspect that this case dealt with was the issue of the doctor-patient relationship. Do we need to have a doctor-patient relationship for one to lodge a complaint. And this judgment said a doctor-patient relationship is not a prerequisite for the council's jurisdiction. So anyone, colleagues, can lodge a complaint. The first thing is, are you registered with the HPCSA? The second thing is, if proved, does this constitute improper, disgraceful, dishonorable, and unworthy conduct? And the most interesting part about this is that who decides whether this conduct is improper, disgraceful, or dishonorable, or unworthy of a profession is the members of the board. The board is the one that makes this decision. So anything, colleagues, it depends on the view of the board. Is it proper for you to batter your wife? That decision remains with the board. Is it proper for you to drink to a point where you forget who you are? That is still the decision of the board. So this is just open. And it is on that basis that the HPCSA or the board has got such a broad jurisdiction in terms of the issues of discipline. Then let me deal quickly with the issue of the mediation of complaints by the chief mediator. Now, I'm not going to dwell much on this one, but just to understand, colleagues, that the chief mediator is established in the regulation. You are not going to find this in the Act, and is to bring some form of alternative dispute resolution in the HPCSA processes, which are basically adversarial at both the preliminary committee of inquiry and at an inquiry level. So the chief mediator is there to bring in the aspect of mediation. So first thing that I want to send as a message is that at least when your matter is with the when I use ombudsman, just know that I am used to that name because I exited the HPCSA being called ombudsman, and so I'm not used to this word chief mediator because I'm not operating in the space anymore. So when the ombudsman considers the matter, there is no issue of trying to find you guilty. It's to find the best way to resolve that particular matter amicably. So when your matter is sitting with the ombudsman, with the chief mediator, you need to relax a bit and allow the chief mediator to facilitate the resolution process. At the end of the day, you have a choice to make, whether you want to agree with the proposed resolution of the matter, which is called a determination by the chief mediator, or not. And if you do not agree, then the matter goes to the preliminary committee of inquiry. But if you and your patient or the complainant agree to the resolution of the matter, at times, in fact, practitioners even volunteer the resolution without the chief mediator saying anything. And if the patient or the complainant is agreeable to that, then that can become a resolution of the matter. They just become the determination of the chief mediator, and the matter is resolved, closed. It does not appear on your record, then you can move away freely. But where you don't agree with the determination, or the patient or the complainant does not agree with the determination of the chief mediator, then the matter proceeds to a preliminary committee of inquiry. So I'm going to leave it here, especially on the level of mediation, which is an alternative dispute resolution mechanism. And let me move now to preliminary inquiry. Now, this is the level of the board. What I need to mention maybe as I close on the aspect of the chief mediator is that anything that happens at the mediation level cannot be shared with the board. If the matter has to be referred to the board, it has to be the original complaint. Whatever you have submitted as an explanation to the chief mediator cannot be taken to the board. It remains with the chief mediator, and that information is strictly confidential. it cannot be shared. The original complaint and the process has to be started afresh on the other side at a preliminary inquiry level. Just checking my time because I need to have time for questions. Now, what I need to emphasize, colleagues, is that how a matter is dealt with at an preliminary inquiry level, it really basically depends on how you respond. Very key, colleagues, the first question is, when you are requested to submit an explanation, you need at least to respond to that, because whether you respond or you do not respond will determine how the matter is handled. And let's talk about a scenario where, as a practitioner, you do not respond to the request for an explanation by the HPCSA, and you're going to receive that from the investigator who is investigating that case. If you do not respond, this is what is likely to happen. The committee may instruct you, and this is an instruction, not a request. The committee may instruct you to appear before the committee in the next meeting to explain to the committee why you did not respond to the complaint. And if possible, they can still give you an opportunity to respond to that complaint. But what may happen, and this is very critical to understand, colleagues, outside the complaint that has been lodged, the committee, depending on your representation, why you did not respond to the complaint, may decide to make a guilty finding against you of contempt of counsel. Now, this one is serious because you can only appeal that guilty finding and the penalty in the High Court. And it runs separately from the original complaint. Even if they give you an opportunity to explain the original complaint, they can even come to a decision to say there is nothing wrong that you have done. That is what we call finalizing that matter in terms of Regulation 47. Even if you are not found guilty by the prelim, or the prelim comes to a conclusion that there is no prima facie evidence of unprofessional conduct, if they have made a guilty finding of contempt of counsel, that one still runs, even though you are exonerated on the other side. And this emphasizes the point why you need to respond. Even if your response is to state that you want to exercise your right to remain silent. And when you opt to exercise your right to remain silent, then that matter will go straight to inquiry. It won't be considered by the preliminary committee of inquiry, because then you will open your mouth at the inquiry. Maybe you don't want to say anything at a preliminary level, but you want to say something at an inquiry level. So it's very much important to understand that how you respond is very critical. I am not going to dwell much on the manner in which certain investigations may be instituted in terms of Section 41A, except to state that this is a section specifically for the registrar. And this is a section that the board cannot be involved in. I just published an article now in April in the Jure, that is the UP Law Journal, specifically on Section 41A. But of importance that you need to note, colleagues, is that you cannot have a situation where there's a search and seizure in your practice without a warrant. There has to be a warrant from the magistrate for that to be done, and it has to be limited specifically either to the complaint or to the issue specified in the warrant. And there are conditions under which the registrar can institute an investigation in terms of Section 41A. Sometimes it's when there is alleged that maybe the Health Professions Act has been contravened, and here you don't know whether there is somebody who is involved, who is registered. And in the second instance is when you are inquiring or investigating if any person who is registered under the Health Professions Act is involved in that particular matter. And the last one is when there is a complaint that has been lodged. I won't dwell much on this one. So basically, in terms of Section 41A, colleagues, is that even when there is no complaint, if the report that is compiled by the investigator reveals prima facie evidence of unprofessional conduct, then that report becomes a complaint, and then for the purpose of inquiry in terms of Section 41, and where it reveals issues of impairment, then the matter will be dealt in terms of Section 51. That is the one that deals with impaired practitioners. I've already explained how the preliminary inquiry will look at your matter and how you can be found guilty of contempt of counsel if you don't respond to counsel. Now, if the matter is finalized in terms of what we call Regulation 48, that is when now the preliminary committee of inquiry come to either two decisions. Decision number one is whether there's prima facie evidence of unprofessional conduct. If the answer is no, then the matter is finalized in terms of Regulation 47. That is where they say, we accept the explanation and you are released. Now, in terms of the current regulations, colleagues, the complainant is allowed to appeal the decision of the preliminary committee of inquiry. Because I've got issues with this amendment in the regulations, because it creates an appeals committee of the board, whereas in terms of the act, the appeals committee is the committee of the council. And for obvious reasons, in that you cannot appeal the decisions of a preliminary committee of inquiry, because in terms of Section 20, and this matter was also emphasized this year in the case of the HPCSA and the HED, where in terms of that case, specifically paragraph number 30, the court held that Section 20 specifies which structures of counsel can be appealed. The decision is of the council, the professional board, and the professional conduct committee, not the preliminary committee of inquiry. And the current regulations only gives a complainant an opportunity to appeal, but not a practitioner. And that constitutionally is wanting, but I'm not going to dwell much on that part. But just to move on now, that is in terms of Section Regulation 47. And further than that, then if the committee says there's prima facie evidence of unprofessional conduct, then there are further questions to ask. One is it minor or serious? If it is minor, then they can impose a penalty or give a caution or a reprimand. The preliminary committee of inquiry is empowered to do so. Now, of note, colleagues, that guilty finding and the penalty of the preliminary committee of inquiry does not go into your record. So it's not going to be a judgment against you on the register. On the register, you will still appear clean. And if they say the matter is serious, then they refer it to inquiry. And while referring it to inquiry, there's also an option that they can give you, that if you want, you can pay. They can say you can pay an admission of guilty fine, and the matter will not go into inquiry, or there is no option to pay an admission of guilty fine. So they've got those options to make. And when they've made that decision for the matter to go to inquiry, then the matter will go to inquiry. There have been changes in the regulations where instead of you being informed 60 days before the inquiry is held, now you are informed 30 days before the inquiry is held. And the charges that are placed before you are based on the points of inquiry from the preliminary committee of inquiry. Now, the current regulations that were promulgated last year has empowered the pro forma complainant to be able to amend to a certain extent immaterially, meaning that the pro forma complainant can change the charge, crafting the charges, can just make it more intelligible than what came out of the points of inquiry of the preliminary committee of inquiry, as long as they are still aligned to the points of inquiry. Now, of importance, colleagues, is that the whole professional conduct inquiry process is like what happens in the court of law. Procedurally so, that is what happens there, and is always advisable. While you may not have a legal representative at the preliminary committee of inquiry, when your matter goes to inquiry, you are advised to have a legal representative because you may not understand the legal procedures that are involved there as a practitioner. Highly advisable. Unfortunately, if you are not having a professional indemnity like your MPS, it can be very costly. And I'm saying this because in many cases, you will have to have an attorney, and that attorney may want to have counsel, meaning an advocate whom the attorney is going to brief. And the moment you know an advocate is going to be involved, you must know the costs are going to be very serious. And we are not talking about colleagues. This process can drag so much that you can just go for a sitting of 2 hours and the matter is adjourned to the following day. You're going to pay the fees for the full day for that attorney and the counsel that is taking that case on your behalf. So it's always advisable to have your professional indemnity should you get into that space, because when your matter goes into inquiry, you will need legal representation. You need legal representation because you may not understand the legal procedures that are involved there. Of course, at the end of the inquiry, you have an opportunity also to appeal the decision of the Professional Conduct Committee. And in terms of PAJA, by the way, colleagues, any decision at whatever level, because the HPCSA performs a public function and exercise public powers in terms of PAJA, you can also take any decision of the HPCSA for review in terms of PAJA, but it's not anything that you can take in terms of the appeal in terms of Section 20. I think I'm going to stop here so that we can have time for questions if there are any questions. Some of the issues we can address them through questions. And Mark, I'm done and back to you.
Thank you very much. And thank you for a very comprehensive overview of all the regulations governing us. We have time for a couple of questions, so I'm going to proceed with those immediately. The first question comes from a pediatrician colleague in Waterfall. Good evening, colleagues. What is the purpose of the appeals process in the HPCSA after a complaint has been addressed at the preliminary committee? From what I understand from what you've just said, there isn't an appeal following the preliminary committee, but perhaps if you can deal with that question. Thanks first.
Yeah, let me deal with that quickly. That is the Regulation 4A, which is an amendment in the 2023 regulations, where now the complainant, not even the respondent, can appeal the decision of the preliminary committee of inquiry. And that is to the appeal committee of the board. So that's why I'm saying that amendment is problematic in many ways, because if you lodge a complaint as a complainant and they say the practitioner is not guilty, and considering that the preliminary committee of inquiry is a committee of experts who appears, who can be able to make that determination, and hence there was never a provision in terms of Section 20 for the decision of the prelim to be appealed in the High Court. But now these regulations have introduced an appeal mechanism where a complainant, only a complainant, by the way, not the respondent, can appeal that decision with the appeals committee of the board.
Okay, thank you very much. I'm sure that the findings of the preliminary committee have raised many questions. I know one question that I've been asked many times is, how does the Health Professionals Council preliminary inquiry justify handing a fine for a minor offence? What that looks like, of course, to a patient, their relatives, or anyone outside is like, well, I paid my money and I'm off now. Nothing on my file. It looks like a bribe. of course. You know, how is it justified, and how would they explain that?
Mark, it's provided for in terms of the Act, where the Preliminary Committee of Inquiry is empowered to, maybe a fine is even better, Mark, because you do have a situation where you have got a caution or reprimand. I know of a case where a pediatrician, a pediatrician who misses a neonatal meningitis, at a level of a pediatrician, if you are an intern, maybe that could be, but a pediatrician missing neonatal meningitis and you go away with a caution or reprimand, that is on the wrist to say, so please don't do this again. So it is unfortunately how the Preliminary Committee of Inquiry determine whether this one requires a caution or reprimand or this one requires a fine. It's not necessarily prescribed or regulated. It is the decision of that committee at that particular time. And even the amounts of course are prescribed. There's a guide in terms of this kind of an offense. You need to start from 5,000 to this much. This one, at least you should hit at this level.
Thank you very much. I think William has the next question for us.
Thanks so much, Mark, and thank you, Dr. Quinda. So this question touches on the contentious issue of impairment. Dr. Mahomva asks, if you report in good faith that a colleague is impaired, do you have any protection from the colleague suing you in a court of law?
That is a very important question that the colleague is asking. And I'm saying this because not only for impaired practitioners, when you are a complainant, there is a case that I know has not yet been finalized, and I'm very much interested to know how this matter is going to be finalized, because it talks about frivolous complaints, where sometimes colleagues can hit each other or try to really just embarrass a colleague by lodging a complaint, where now if one is not found guilty, can I turn around and say, this was frivolous, and now I take you for defamation in terms of the civil procedure. And I can tell you now that anyone has got a right in law, and it will be the decision of the court to decide if indeed he or she has got a case of defamation against you. But when you can decide, I know now there is a mechanism where now you can report somebody anonymously to the HPCSA, and that is where the Section 41A comes in. And there's a provision in terms of Section 41A that if that investigation reveals prima facie evidence of impairment, then Section 51A will be invoked. So if one is scared to disclose themselves for fear of being even victimized afterwards, whether it's a complaint not related to impairment, but just unprofessional conduct, one can remain anonymous and allow the HPCSA to investigate the case.
Oh, thanks so much for that, Dr. Quinda. Maybe you should write your next article on that section.
Yeah, I will consider doing that.
Dr. Human, back to you.
Thank you. We have a third question coming from Khabane Maloto. This actually sounds like it's written by a lawyer because it has words in it that I don't understand. Does the fact that the Act does not require complaints to be reduced to sworn written affidavits binding complainants to the veracity of their allegations not negate jurisprudence ethics in contemptuous of court judgment in De Villiers versus the South African Medical and Dental Council? I hope you know what that court judgment is, because I have no idea.
Mark, and I do understand the person who has asked this question. And this is one of the issues that has been a concern. And you only have the provision in terms of the suspension regulations for the affidavit. But it does not necessarily mean that if a need be, then that cannot be asked for, especially when a practitioner has to be suspended. In terms of the suspension regulations, from what I know currently, that is the only time when an affidavit from the complainant will be required, because when you are suspended, as part of the investigation by the HPCSA, you cannot be able to continue practicing your profession. Hence, then a complainant may be required to have a sworn affidavit so to confirm that particular complaint. So I only know from the provisions of the suspension regulations, but not where now somebody has just lodged a complaint. They are not required to do so.
Okay. Thank you very much. William and I are sort of tag teaming here to give ourselves a chance for our brain to cool off after each question. You're the next one, William.
Thanks. Don't worry, Dr. Quinda. It's not a good cop, bad cop situation. You're not being interrogated. The next question is, and also an ethical conundrum. What protection does a doctor have when he feels that himself is impaired?
Okay.
What is there to encourage a colleague to self-report?
Wow, very nice question, that one, William. And thanks to the colleague who asked the question. In fact, you will be declared an impaired practitioner. And if when investigation is done and assessments are made, you are impaired, then you will be declared an impaired practitioner. When you are declared an impaired practitioner, it's more protective to you as a practitioner, because should something happen, and there are many reasons why colleagues can be impaired. Some colleagues, and I'm talking from some of the experiences that we have had, somebody may not be able to work 8 hours a day because of the kind of conditions that they have, and they can work limited time. Some people have got mental conditions that should they relapse, during, let's say, for example, when you are seeing a patient and something happens that can be categorized as unprofessional conduct, the fact that you have already been declared an impaired practitioner will protect you. So basically, when you are an impaired practitioner, unless really it is so bad, and you will also understand that you also do not want to cause harm to patients, if your condition is so bad that you can't be able to practice your profession. But in the main, being an impaired practitioner, if you are declared as such, is more protective to you as a practitioner, but also protective to your patients as well. That's why I mentioned that the unfortunate part is that at times you may have to cease practicing your profession because of your impairment.
Thank you very much. Our next question comes from Reiki Liebenberg. Thank you for explaining the role of mediation. I understand that it could be an alternative way of handling a complaint, but in my one experience of this process, I still felt it was prejudiced against the practitioner. I assume she's talking about the mediation process, that is the HPCSA preliminary inquiry. Of course, you can have a mediation process that prevents an HPCSA complaint, and that's a separate issue. Where is our protection against what is basically nuisance complaints? The only one in our corner is supposed to be SAMA. How are we being protected? Do I now have the redress against the patient for wasting everybody's time? Is there some recourse if someone files a frivolous complaint?
Yeah, it's what I was referring to earlier, Mark. Unfortunately, as it is right now, anyone can lodge a complaint, even if it is a frivolous complaint. And it will really depend on the aspect of regulation number 2 that deals with the perusal and analysis of that complaint by the registrar or the person who has been delegated by the registrar to be able to pick that one up, especially in cases where there could be a jurisdiction. Let me give you an example. There have been complaints about colleagues who are involved in a contract, for example. If one breaches a contract, why can't you go to the civil court? Why should the HPCSA be dealing with that matter? So we do have such cases where it will depend really on the person who is dealing with that case in terms of perusal to refer the matter to the relevant jurisdiction, because that is provided for in the regulations. But at the same time, there can be frivolous complaints, and from my experience, even personal experience, that is happening where somebody may just want to get at you and lodge a complaint against you, and you have to go through the whole process. The moment is put before the prelim and you are required to respond, you still have to respond even if it's a frivolous complaint. Unfortunately, you cannot neglect that. You still need to respond. Allow the Preliminary Committee of Inquiry to decide on the matter. And as I said earlier, if you want to take further action, that has not yet been tested in the court of law. I wish we can have such a case so that you can have precedents, but that has not been tested in the case of in the court of law to say, if you are not found guilty by the HPCSA, can you turn around and open a case of defamation? You are muted, Mark.
Thank you very much. So what I'm understanding is the discretion as to whether to take the complaint forward really sits with the Preliminary Committee of Inquiry initially, and that's kind of the filter against frivolous complaints. But there is, correct me if I'm wrong, there is nothing stopping anyone from actually taking their patient, if they are persistently harassing the practitioner, to court in a civil case of law for whatever it would be, harassment or persistent false allegation, something like that. Does that sound correct?
It's correct. First thing to correct something, Mark, is that the process starts with the registrar, not the Preliminary Committee of Inquiry. The registrar, in terms of perusal and analysis and categorization of the complaints, the process starts there. The person who is doing that particular function is very critical to be able to sift and say, is this matter supposed to go on? Now, from there, then the matter goes to Preliminary Committee of Inquiry. In terms of even case law, it also plays a sifting process. That's why it works on, is there prima facie evidence of unprofessional conduct? And making that determination is also a sifting process where they can be able to conclude that there is nothing here, then they close the matter. And if there is something, they can decide on how to deal with the matter. But anyone still have their rights as citizens of this country. That right is not taken away from you because you are a practitioner. If you feel that you are being harassed through your regulators process, you can take that person in terms of the civil procedure.
Thank you very much. William, are you going to take the next one? Thanks.
Yeah, I just want to add to that. And you're also welcome to contact SAMA's legal division, who'd love to assist you. I know there was the case of, and I don't want to get this wrong, Holden versus Asman, where it was decided, or it does potentially open the door for practitioners to bring claims of malicious prosecution against complainants that lodge these frivolous claims. And that case is seemingly still ongoing, but please feel free to reach out to us. I think, Dr. Quinder, just for the sake of you being able to catch that last train out of Johannesburg, the rest of the questions we'll answer offline and get back to the individuals. And I think at this stage, I might just throw it back to Dr. Human to close for us. But from my side, I just want to say thank you so much, Dr. Quinder. I think we've all greatly benefited from your valuable insight and experience as the previous ombud at the HPCSA. It was an absolute pleasure. And to all the colleagues online who's joined us as well, thanks so much. Dr. Human, back to you.
Thank you very much, William. William's the head of our legal department in SAMA, for those of you who did not know that. And thank you very much, Dr. Munyadziwa Quinder, for your expertise in all of these issues. I hope this has been in many ways an elucidating experience for many of you. I certainly have learned some things. As I said at the beginning, this is the first in a 4-part webinar series that we are having, thrashing out medico-legal issues. Our next one is next Tuesday, which is Tuesday the 17th of September. Advocate John Sainer, who does an incredible amount of medico-legal work, is going to be talking on what is medical negligence. And of course, you will be aware, or most of you will be aware, that the concept of the reasonable doctor is that against which we get tried if we are suspected of medical negligence. So John's got a very nice way of putting things in a very easy to understand fashion, and he's written a wonderful book, which no doubt he will tout at his talk. But he'll be talking about the concept of a reasonable doctor and how that relates to medical negligence claims. All right, everyone, I'd like to say thank you very much. Thank you to Sama for our hosts. Thank you to Professor Ames Dye, who keeps us all honest in the Health Policy, Law and Ethics Committee that basically this falls under. And I wish you all a very pleasant evening.
Thank you. Bye-bye.